Hey, we are talking today about the beginning of a criminal case for DWI, which is the traffic stop. Anytime we have a client who's been arrested for DWI, one of the first things we want to do is try to get the case dismissed because the traffic stop is invalid. There's this doctrine under the law called the fruit of the poisonous tree doctrine, and that says that if an officer's made an illegal search or an illegal stop or an illegal detention of someone, it says they have to have reasonable suspicion that criminal activity is afoot. Sometimes this is referred to as probable cause. That's wrong. Actually, the reason an officer pulls you over only needs to be reasonable suspicion, not quite as high as probable cause. But in any case, if the officer doesn't have that, then that means it's an illegal traffic stop, and any of the evidence, including evidence of intoxication, could be suppressed, meaning that the state would not be able to proceed forward with a trial, and you can't be convicted for evidence that's obtained during an illegal stop. This fruit of the poisonous tree doctrine is the heart of American criminal jurisprudence under the Fourth Amendment, which says you have the right to be free of unreasonable searches and seizures of your person. And so a traffic stop oftentimes is done for an officer because they think they've seen some violation of law. For example, speeding. If you get pulled over for speeding, then an officer could then talk with you, determine that they smell alcohol, and ask to begin doing field sobriety tests, something like that. But they first have to show they have specific and articulable facts that lead the officer to believe criminal activity is afoot or may be afoot in the near future. And a famous case on this in Texas is the Dershweiler case. In Dershweiler, somebody smiled at another individual in a parking lot. Everybody thought that was strange, and it made them think that something might be happening. That's about as far as the Court of Criminal Appeals in Texas will go for reasonable suspicion. And it says that, in fact, that is reasonable suspicion. So, other examples, one we get a lot of headway with is failure to maintain a single lane. So, officers often don't understand this law requires a dangerousness element. So, they'll say, oh, I see a car, it's failing to maintain a single lane, but it's not simply failing to do, or it is simply failing to do that. There's nothing dangerous about it. There's no other cars in the area. It's just barely crossing the line. They turn on the red and blue lights, and that indicates that a traffic stop has been initiated. Um, if an officer confronts somebody in a parking lot or there's a case called Garcia Cantu versus State out of Montgomery County. And it says that in that case, there was somebody stopped in a cul-de-sac, and someone, anonymous caller, called it in for suspicious activity, but didn't have any particular criminal activity they were discussing. The officers immediately came up and put their red and blue lights on, indicating a traffic stop was being initiated, even though there was no specific articulable facts that would lead an officer to believe that criminal activity was afoot. It would just led them to believe that there was a car there. It could have been car trouble. It could have been 100 innocuous things. In that case, there ended up being, I believe, drugs in the vehicle, and those were suppressed. But it'd be the same if it was a DWI. If somebody was parked in their car, had their foot on the brake, vehicle is in drive, they would consider that operating the vehicle probably. And then if the police come up before they have a specific reason to stop the vehicle, then that is going to be an illegal stop. So there's lots of different traffic stops out there, a huge list of them, and there are specific elements officers have to meet. They don't have to meet all the elements of a crime in order to meet reasonable suspicion as that standard. But if they're clearly missing any evidence of one of these elements, then the courts, especially with that failure to maintain a single lane, will often dismiss the charge because there is no evidence that can be used in the case. So that's always the first part of a DWI case, is challenging that traffic stop.